Welcome. In this video, I'm going to explain how an advocate can apply for a defendant's case to be dismissed, even before the jury has retired to consider the verdict. I'll explain the rules, and then my friends will show you how it's done. Let's begin. A defense advocate in a criminal trial can apply to dismiss the case against the defendant, even before the jury has retired to consider the verdict. The application is called a submission of no case to answer. If successful, it has the effect of stopping the proceedings against the defendant. The application can be made in a magistrate's court and in the Crown Court. Today, my colleagues and I are going to focus on the Crown Court. In the Crown Court, because the judge is the judge of the law, a submission of no case to answer is made to the judge, in the absence of the jury. So, exactly when can a submission of no case to answer be made? Generally, after the prosecution has presented all the prosecution evidence and formally closed the prosecution case against the accused. But note, where a defendant is charged with certain offences, the submission of no case to answer cannot be made until after the court has heard all the evidence, including any defence evidence. This is the case where the defendant is charged with the following offences: murder, manslaughter, attempted murder, causing harm contrary to Section 18 or 20 of the Offences Against the Person Act 1861, an offence of causing or allowing a child or vulnerable adult to die or to suffer serious physical harm contrary to Section 5 of the Domestic Violence, Crime and Victims Act 2004. Let's turn to the test to be applied when making a submission of no case to answer. Rules partially reflects the test set out in the Court of Appeal case of R and Galbraith, which remains good law. The general approach to be followed was decreed by Lord Lane, then the Chief Justice. Of the application is successful. If the indictment contains multiple counts, and the submission of no case to answer is successful on all counts, the judge will direct the jury to return a verdict of not guilty on all counts. This will end the trial. If the indictment contains multiple counts, and the submission of no case to answer is successful on some counts, the trial will continue on the remaining counts, and the defence will be invited to present its case on those counts. If the indictment contains multiple counts, and the submission of no case to answer is unsuccessful on all counts, the trial will continue, and the defence will be invited to present its case. You're going to see how a submission of no case to answer is dealt with in the Crown Court. The defendant is accused of assault occasioning actual bodily harm, contrary to Section 47 of the Offences Against the Person Act 1861. These are the facts of the case. This is the case for the prosecution, Your Honour.
Your Honour, a point of law has arisen. It need not concern the jury. Your Honour, I submit that there is no case to answer. In support of my application, I'll be relying on the CPR Rule 25.9, subsection 2E, and that is that the prosecution evidence is insufficient for any reasonable court properly to convict. I also rely on the second limb of R and Galbraith. That is that the evidence presented by the Crown is of such tenuous character that a jury properly directed could not properly convict upon it. If I could first deal with the description of the person who assaulted Mr. Smith. Your Honour may recall the evidence of Mr. Smith. In examination in chief, he described his attacker as being a 6-foot-tall, heavily built, bald man. Now, Mr. Smith wasn't able to describe the man's skin colour, facial features, hairstyle, or hair colour. And in my submission, the physical description matches countless individuals. There is nothing distinctive or striking about the description provided. In terms of what the man was wearing, in cross-examination, Mr. Smith stated that he wasn't able to recall what the man was wearing, other than that he was wearing dark clothing. Now, it's conceded that Mr. Hill is 6 foot tall, bald, and heavily built, and that when he was arrested, he was wearing black jeans and a black hoodie. However, Mr. Hill was wearing a very distinctive type of hoodie. Police Constable Lewis, in cross-examination, said that the word Viper was displayed in very large white letters across the front of Mr. Hill's hoodie. He also accepted that he had never seen this type of hoodie before. If there had been any physical interaction between Mr. Hill and Mr. Smith, one would have expected Mr. Smith to have noticed and later described the clothing. In addition, an identification procedure was carried out 2 days after the assault. Mr. Smith did not pick out Mr. Hill during that procedure. Turning now to Mr. Hill's injuries, the prosecution adduced evidence of bruising to Mr. Hill's knuckles. In fact, Mr. Hill explained in his police interview how the bruising occurred. He explained that he is an amateur boxer and that he sustained the injuries following training. In my submission, there are other weaknesses in the prosecution case. No CCTV evidence was produced by the prosecution. No forensic evidence linking Mr. Hill to the commission of the offence was produced, and no witnesses were produced to corroborate Mr. Smith's description of the person who assaulted him. Your Honour, in my submission, it's clear that the evidence is vague and tenuous and certainly not strong enough for any reasonable jury properly directed to convict. I would invite Your Honour to find that there is no case to answer. Unless I can assist further, those are my submissions.
Your Honour, the prosecution submits that when viewed in totality, the evidence against the defendant is sufficient to leave to the jury. There is evidence upon which a jury could properly come to the conclusion that the defendant is guilty, and therefore Your Honour should allow the matter to be tried by the jury. Mr. Smith provided a description of the man who had assaulted him. While generic, the description was specific enough to precisely correspond with the defendant's appearance. In addition, given that the assault occurred in the early hours of the morning, in a very quiet area of town, in my submission, the probability of another individual with the same physical characteristics being present at the location is exceptionally low. Furthermore, the assault took place at 3 in the morning. The defendant was arrested 20 minutes later, in close proximity to the location of the assault. Police Constable Lewis stated in examination in chief that the defendant was arrested at a bus stop on Kimball Street. Kimball Street is 500 metres from Wilson Street, the location of the assault. I submit the proximity of the defendant to the crime scene, both in terms of timing and geography, is strong circumstantial evidence linking him to the offence. Finally, when arrested, PC Lewis noticed bruising to the knuckles of Mr. Hill's right hand. In his police interview, it was put to Mr. Hill that the injuries were incurred as a result of punching Mr. Smith. Mr. Hill denied this, but in my submission this is a matter for the jury to determine. In conclusion, there is evidence upon which a jury, properly directed, could convict Mr. Hill. Unless I can assist further, those are my submissions. What do you think? Would you grant the defence application, or would you refuse it? See you next time.